confer with the state on this motion to travel?
We have, Your Honor.
And
We're unable to reach an agreement, Judge. If I'm going to approach with what the state can agree to so that I don't continue to repeat myself.
Whoa, burglary, no contact orders, and Disney World all tangled into one courtroom moment. You know this case isn't going to be simple. Keep watching because things are about to get legally messy and emotionally intense.
We're in agreement that she be allowed to go to the Make-A-Wish trip with the complainant, but I believe that we have a disagreement on whether the order subsequent to the return should be no harmful injurious contact, meaning they could have full contact, versus the state is not comfortable with that. And
all right, so the court is saying, let's just go with she can do the Make-A-Wish. And then when she comes back from that, then we can address the other issues, because I'm going to need witnesses here so I can make an informed decision on the no harmful or injurious contact, because the only thing I know about this case is it's a burglary of a habitation with the intent to commit assault. I don't have any facts about the case.
The judge is holding off on big decisions until everyone's heard. That's Courtroom Strategy 101. Don't rule without evidence. But do you think she should have allowed full contact just for the trip? Let us know in the comments.
That's the only thing I know. I'm assuming this is the Make-A-Wish to Disney World. All right.
And then regarding child exchange, they still need to go through other.
Yes. And if you'll just get a setting from Ms. Ferguson, I will hear that as soon as she comes back from Disney World, or as soon as you want it back after she comes back from Disney World, because it shows here that it's from January 23rd to January 29th.
That is correct, Your Honor.
All right. So if you want to set it for hearing immediately thereafter, the court will hear it, and you do not have to file another motion. So my understanding is the state is in agreement for her to travel to Disney World, but the orders will be reinstated once they arrive back. And when they arrive back, if you'll speak with Ms. Ferguson before you leave here today, we can immediately put it on the docket for the court to hear it, and I'll expect the complainant to be present.
Thank you.
All right.
May we be excused?
Yes, if you want to get a date from Ms. Ferguson.
Yes.
2022 CR 5919, State of Texas versus Lindsay Pierce. Can I have parties announced for the record for the state?
Travis Banks, the State of Texas.
Defense?
Jason Todd for Ms. Pierce.
And are you Lindsay Pierce?
Yes, ma'am.
Counsel, you received all the discovery, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Pierce, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, no, the state will make a motion to proceed on lesser included assault, bodily injury, Class A misdemeanors.
Any objection?
There's no objection to that, Your Honor.
All right, Ms. Pierce, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury as a Class A misdemeanor? Range of punishment is anywhere up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to a $4,000 fine and up to 1 year? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your
Court
Honor.
will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the Class A misdemeanor assault bodily injury. There's a $500 fine. State recommends deferred adjudication. There's restitution, if any, to Brandy, B-A-R-A-N-D-I, Zamora, and Brett, B-R-E-T-T, Aguilar, and the APSC course. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That is correct, Your Honor.
Showing you outside the agreement, the state is requesting that you...
Here's where things get real. Lindsay Pierce pleads no contest to assault. It's a Class A misdemeanor, but thanks to deferred adjudication, she avoids a conviction, for now. Slip up, and she's facing jail. Think of it as a legal tightrope walk.
Deferred adjudication before a term of 2 years. There'll be 50 hours community service restitution. No harm for or injurious contact with Brandy Zamora and Brett Aguilar. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, stated for State's Exhibit 1 and its attachments.
There's no objections to that.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, you want to explain to me what happened? And why I should even consider making this a no harm for injurious contact?
There were a lot of things leading up to this point in time. He was still my husband. I had a 3-week-old baby and 2 younger kids. And that night I had gone over to drop off my daughter's medication, and things kind of spiraled out of control, and I did not make the best decisions that night. And since then, he's now my ex-husband. We worked very hard to get past all of that. We co-parent wonderfully for our 3 children, and have a great relationship for the 2 of us. And I think I can speak for him and I both when we just want all of this behind us so we can continue moving forward.
So where is Brandy in all of this?
They split up, I believe, in September of.
So is that the reason why things are going great for you guys, because she's not in the picture anymore?
Partially, he's able to be a better father and a co-parent, and he was not at the time.
All right. See, I don't understand what people don't understand. When you're in a relationship and you break up, even if you have children, that person can date whomever they want to date. If you think that person is not an appropriate person, that's what the court systems are for. It's not for you to go in breaking windows, injuring yourself, and then having your child know about all this. And I guarantee you, no matter how young your child was at the time, your child knew that there was chaos and trauma going on. So what I can tell you is I'm doing a no contact with Brett Aguilar and Brandy Zamora. And if she wants to have contact or he wants to have contact, then they're going to have to come into court to tell me that that's what they want.
And I appreciate that, Your Honor. We have gone through this in pretrial, and I think we have resolved it pretrial with as far as Brett. But with Brandy, there's no issue with the no contact. I think what we brought up.
No, I mean, have we had a ruling prior allowing her to have contact with him?
For purposes of the children, yes, Your Honor. But if
Yikes. That judge isn't pulling punches. She's right though. Kids pick up on everything. Chaos at home becomes trauma for children, even if they can't explain it. That moment hit like a gavel to the heart.
the lead judge, if you were to set this for a sentencing, that he would come in. This is not an issue. They took a trip to get, one of their daughters is, they had a Make-A-Wish trip, Your Honor.
Yes.
This is that case.
Okay, I see it in here. State agrees that upon return to Bexar County on January 2023, the no contact order is to be restored, with the exception that the defendant may contact the complainant by phone, in video, and may only have in-person contact for the sole limited purpose of child exchange.
And that's what, if we could have another setting, he would come in. That won't be an issue, Your Honor.
All right, well, I'm going to make my ruling now, and then if you all want to bring him in later, you can.
Okay. May we get that date today then with the court? Just get a setting?
Oh, no, I'm going to do my sentencing now, and then you all can come back on a whatever date you want to come in, and I'll hear that issue with regards to that.
Thank you, Judge.
Sure.
That's perfect.
All right, are you employed?
Yes, ma'am.
What do you do?
I do outside sales for an oil and gas company.
Okay. All right, the court will sentence you to 2 years deferred adjudication. And states you're not asking for an affirmative finding of family violence?
No, Your Honor, no affirmative finding is being.
All right, there's a $500 fine to be probated. There's to be restitution, if any, to Brandy Zamora and Brett Aguilar. There's to be no contact with Brandy Zamora. There's to be no contact with Brett Aguilar, with the exception.
And here comes sentencing. No jail time, but a stack of conditions: drug tests, parenting classes, restricted contact, and no working with minors. Makes you wonder, what's the real backstory that never made it on record?
Of child custody exchange. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. There's to be regular UAs. And is there going to be any alcohol problem or any drug issues with you?
No, ma'am.
All right. Ms. Abrams, I'm going to want a UA today. 50 hours of community service restitution. Parenting classes. Once she's completed parenting classes, then the 50 hours will be satisfied. And the APSE course. Probation, is there anything else she needs? Yes, let's do field visits. One time per month for 2 months. And if there are no issues, they can be discontinued or continued as probation sees fit. Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. Whatever your issues are with the partner that you're with or that you have children with, you can't let those issues tumble over into your parenting. Because then guess what? Whatever child you had who's a witness of that, they're experiencing the same trauma and they don't need that.
Yes, ma'am.
All right, good luck to you.
Thank
And
you.
probation, we'll do a UA today.
It would be excused, Your Honor, except for the UA and.
Yes, thank you.
Thank you.
You're welcome. Court is calling 2000, and counsel, you're on this side.
Yes, ma'am.
Court is calling 2022 CR 5919, State of Texas versus Lindsay Pierce. Could I have parties announced for the record for the state?
Ruben Herrera, Your Honor.
Defense.
Andrew Del Cueto for Ms. Pierce.
And are you Ms. Pierce?
Yes, ma'am.
All right, defendant has filed a motion to modify conditions of community supervision. State, have you had a chance to review this document?
We have, Your Honor.
And probation,
Yes, Your Honor.
are you aware of this motion to modify conditions of community supervision?
Yes, Your Honor.
State, are you prepared to proceed?
We are.
All right, State, do you have any objections to the motion?
We do not understand, Your Honor.
All right, and defense, there's a witness that the court wanted present.
Yes, Judge.
All right, if you can call that witness.
Yes, Your Honor.
It's red. There you go. Thank you. I'm telling you, it's one of those days. All right. I'm sorry, what is his name?
Mr. Aguilar, Brent Aguilar, Your Honor.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, and if you'll state your name for the record, please.
Brent Aguilar.
All right, so the court is in receipt of a motion to modify conditions of community supervision, and they are asking, the defense is asking that the no contact order be changed. Are you aware of that?
Yes, ma'am.
All right. Do you have any objections to this no contact order being modified to no harmful or injurious contact?
No.
All right. Do you have any fear of the defendant. Any questions?
No, Your Honor.
State, any questions?
Oh, yeah.
All right, thank you so much for coming in. I appreciate it.
Yes, ma'am. Thank you.
All right. All right, the court will grant the motion. Is there anything else from either side? All right, so probation in this case, the conditions are changed to no harmful or injurious contact with Brett Aguilar. All right, probation.
From burglary to boundaries, this no-contact order just got softened. But will this fragile peace last? Parenting and past trauma don't mix well. Hit that like if you think second chances should come with strict limits.